was convicted of murder for the murder of his wife, Maggie Murdaugh, and his son, Paul Murdaugh, who was at the time only 22 years old. But he was given 2 life sentences. And, I actually have a timeline right here. Hold on, not this one. Timeline right here. Was given 2 life sentences. In September, there was some allegations of jury tampering, possibly by the court of clerk, Rebecca Hill. Now, a little bit about Rebecca Hill. She's an elected official. They elected her to, be the court of clerk. And she was writing a book about the trial. And the book was released about like a month or 2, I think, after the verdict came out. And then she and the jury members, they went on like, I don't know, what do you call it, like a press tour or something? They like traveled. She like escorted them to New York, or they gave interviews and stuff like that. And I think she also gave interviews as well with like Law and Crime, maybe even Court TV as well. But yeah, she really wanted to have her voice out there. But Dick Harpootlian, Jim Griffin did a press release 2 months ago, back in September. And they were saying that, like, we talked to some of the members of the jury. We drove the back houses of blah, 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 these roads and stuff like that out in the country. And we talked to the jury members, and they were saying that Rebecca Hill was, engaging in jury tampering, essentially accusing her of saying things to the jury to influence them about when Murdaugh was about to testify. And then also things about during the verdict as well, when they were deliberating for the verdict. And I think they were saying that, like, they didn't let the jury, go out and have their cigarette breaks when they're supposed to. And there's like 6 members who smoke cigarettes and blah, blah, blah. And so we were waiting on, the response of Rebecca Hill. She kept quiet. She didn't say anything. And it makes sense because, you don't want to just willy-nilly just make a statement, right? You got to get lawyers involved and all that stuff. The state has to get involved. And so today we finally, was it yesterday? Yesterday we get a response from the state for Alex Murdaugh and his attorneys wanting a new trial. And can you imagine if a new trial were to happen? If a new trial were to happen, imagine all the things that Dick Harpootlian, Jim Griffin can do better. Because initially, if you guys remember, the roadside shooting was not supposed to be let in. But Jim Griffin opened the door to that, and the roadside shooting came in for the trial. Same thing with the financial stuff. A lot of the financial stuff was not supposed to come in, but I believe it was also Jim Griffin as well who accidentally opened the door on that, and that all flooded and came on in. But in addition to that, because things were looking so bad for Alex Murdaugh, he had to go up there and testify. And did he really do a good job testifying up there? In my opinion, no. I think he did horrible up there. But I understood why they wanted him up there, or I understood why he probably wanted to go up there, because he's probably like, you know what? I'm an attorney. I've tricked people for 30 plus years. Like, people are going to look at me and they're going to trust me, and I'm going to be able to manipulate them. That's what I think. I think Alex Murdaugh went up there because he had the gall to think that he was going to be able to manipulate the juror and to lie to them again, and to get them to believe that, he was telling the truth and stuff like that. So there's a lot of things that could be done differently if there was a new trial. But I want to read the state's response to it. In it, it's going to have the affidavit of Rebecca Hill, where she's going to disavow some of the things that the jurors were saying, and then also some statements that they got from the jurors as well. So I think the next step would be maybe they'll have an evidentiary hearing to, really figure out, was there jury tampering? So I'm not really quite sure where it's going to go with that, but it's just kind of messy right now, because in this month of November, there's also supposed to be the state financial crimes with having Judge Newman as the judge, who was also the judge for the murder trial as well. And then not only that, but they don't want Judge Newman to be involved in this. Of course, because Judge Newman's had things to say at the sentencing to Alex Murdaugh, but they don't want Judge Newman involved because they're saying like, Judge Newman is way too close to this, Rebecca Hill is his court of clerk, da-da-da-da. And so I can see why they don't want Judge Newman to be involved. But I don't know. The state financial trial is supposed to happen in like 2 weeks. Like, I think literally the weekend after Thanksgiving, it's supposed to happen. So we'll see if that's going to happen or not. I don't know. All right. So we got the state's response to defendant's motion for a new trial and state's motion to strike. So we have Richard Alexander Murdaugh was convicted for the murders of his wife, Maggie, and son, Murdaugh, by a jury before this court in Carleton County on March 2nd, 2023. I can't believe how much time has flown since then. Now, after filing for a notice of appeal and during the pendency of that appeal, Murdaugh filed in the Court of Appeals in South Carolina on September 5th a motion to suspend appeal and for leave to file a new motion for trial. And that's when they did the press conferencing with Dick Harpootlian, Jim Griffin. And so Murdaugh broadly claims he is entitled to a new trial based on allegations that the court of clerk, oh my God, my dog is just kicking my camera right now. You got an earthquake going on. Murdaugh claims that Rebecca Hill improperly attempted to influence the jury's decision. Now, in support of his claim, Murdaugh offers affidavits from one juror who participated in deliberation, one who was removed for dishonestly concealing her own improper communication. Now, that's the egg lady, if you guys remember, the egg lady that was kicked off. And then she was like, well, can I get my eggs, please? And everyone's kind of like laughing at that. There's also 2 hearsay affidavits from his counsel's paralegal. Now, a little bit about these affidavits from the counsel's paralegal. So they had 2 of the jurors who apparently talked to them, but they never actually gave like a sworn affidavit because they were too busy to come back to sign something so important. I don't know. That's what the Murdaugh attorneys say. So I don't know, but they're hearsay docs, I guess. Murdaugh additionally advances a sweeping conspiracy theory about a wholly irrelevant Facebook post with scant evidence to support it. The state responds as follow. Now, the Facebook post thing, I did find it a little bit shady from Rebecca Hill's side because she said she saw a Facebook post and she was like, she had enough of it and she just kept scrolling down. It's like, why didn't you just take a screenshot of it? It's so easy to take a screenshot on your iPad, on your phone. Like, why didn't you take a screenshot of it? Because later on, when she tried to find the post, she said that she couldn't find it anymore. So they're alleging that she like made up this post in her mind and it was actually a real thing. Okay, so this is the state's response. 1, law and procedure. Colorable? Is that a word? Colorable claims, I guess it means like colorful claims, after discovered improper external influence on jury may necessitate a judicially conducted inquiry to confirm the validity of the verdict as free from external influence through the defendant must show actual prejudice. All right. So the law permits, but skeptically receive motions for a new trial based on after discovered evidence. And never does the law permit highly motivated convicts to put their own jury on trial. I'm going to skip the quotes here. Oh, yeah, it just popped up. Thank you so much, Alice. I appreciate it. I'm not sure how to take a screenshot on my phone. Leon, what phone are you using? I'll teach you. Nonetheless, criminal defendants have a right to a fair and impartial jury, and private communications or contact with jurors during a criminal trial about the matters pending before them may necessitate an evidentiary hearing, and a defendant can show actual prejudice, a new trial. So that makes sense. Skip through this. Not every inappropriate comment made by a member of the court, staff to a juror rises to a level of constitutional error. Were that the rule, field trials would be constitutionally acceptable. Additionally, jurors are presumed to follow the law as instructed to them, to include instructions of what constitutes proper evidence and to consider into deliberations. Why was that so hard to read? To consider in deliberations. And such instructions are usually deemed to have cured the erroneous exposure to improper evidence or argument. Now, where defendant knows or could have known of a constitutional issue at the time of the trial, defendant is obliged to timely raise that issue to the court's attention, or else write it in future appeals. Where defendant does not learn of constitutional violation until after the trial, the defendant is obliged to seek relief within 1 year of actual discovery of violation, or when it could have been discovered through reasonable diligence, or within 1 year of setting a remainder from appeal. A prima facie, so prima facie is like at face value, I think, showing that a defendant is entitled to relief is necessary before an evidentiary hearing can be granted. A jury poll may cure any procedural irregularities and confirm that each juror approves of the verdict returned and that no one has coerced or induced to agree to a verdict to which he or she does not actually assent. Now, I think at the end of like when they read the verdict, I think the defense wanted to have a jury polling where they asked the jury, like, oh, is this your true and final decision? Did anyone influence you? And they all like give their answer at the end. And so they did do the polling. If that prima facie showing is made, the resultant evidentiary hearing is strictly limited, judicially conducted affair, particularly as concerns examination of the jurors. The competency of the jurors and witnesses is strictly circumscribed by the rules of evidence. And that's the quote that they have there. I'm talking about the green. Okay, so here are some of the questions. Was your verdict guilty of both charges? Is that still your verdict? Was your verdict based on 1% on the testimony, evidence, and law presented in trial? So these are, I guess, different variations that they can ask the juror at the very end. Thus, the established practice is that when considering allegations of inappropriate communications, the court should voir dire the complaining juror, each juror who engaged in the final deliberations, and the alleged improper communicator, with at least one, whether the communication actually occurred, and if so, its context and substance. Number 2, number of jurors exposed to the improper communication. Number 3, the weight of the evidence properly before the jury. And 4, the likelihood that curative measures were effective in reducing the prejudice. But for proposed questions submitted subject to judicial, should I wear my glasses? Subject to judicial pre-approval, the court should not permit interrogation of the jurors by the party or the attorneys. So, I mean, Dick Harpootlian and Jim Griffin has already interrogated the jurors. It seems like jurors are citizens who committed tremendous service to their community and country through a sacrifice of time and effort to weigh in on the most serious issue that can be put to them, a man's guilt and his freedom. Jury duty is a cornerstone of civic duty. I'm going to skip through that. Trial. Near the end of Murdaugh's trial, separately sourced reports of improper discussions and social media posts were brought to the court and investigated, resulting in the excusal of juror 785. Again, 785 is a juror who had the Aggies, who now raises allegation he or she expressly denied to the court when examined. Oh, so they're basically saying she's contradicting herself because they did bring her up there and ask her questions, but it seems like she's being contradictory because what she's telling Karputian and Griffin is different. Portions of the trial transcript illuminate or otherwise relevant to resolving the allegations now raised by Murdaugh. The state excerpts and summarizes them as the follow. A. The court consistently instructed jurors to not discuss the case and to only consider the competent evidence present in the courtroom. Now, once the juror was selected, the court promptly admonished the original 18 jurors that, in quotations mark, it is important for you to know that you're not to discuss the case with each other or with anyone else, and not to endeavor to find any information about this case other than what you will see here in the jury in the courtroom. Now, this is something that was mentioned pretty much like any time the jury would take break. This is something that was said by Judge Newman. And so whenever they would take break and then at the end of the court day as well, just a reminder like, hey guys, don't be discussing the case with anyone or amongst yourself and don't seek any information. After the break and during the court's preliminary instruction, it again emphasized the importance of not discussing the case and accepting only the evidence presented into the courtroom. Again, another quote. Consistently throughout the trial and even at points during the jury selection, the court reminded and admonished jurors to not discuss the case. So these are transcripts that they're citing right now. In its charge to the jury at the end of the case, the court instructed the jury they were only to accept the evidence presented, that they're only the sole judges of credibility. Did you found it? It works? There you go. You are to consider only the testimony which is presented from this trial stand, along with exhibits and other evidence presented during the trial. Any other evidence or exhibits which have been made part of the record you may consider, along with the stipulations made by counsel. You are also the judge, the sole judges of credibility, that is the believability of the witnesses who have testified and of the evidence offered. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. Lady, are you excited for jury duty? Is all this making you excited for it? Anyone else have jury duty coming up soon? Let's see. So again, telling them not to talk to each other. B. Certain statements attributed to Clerk Hill by Juror 630 closely resemble statements made by court by the state. So this is the part that I think is really interesting. So there are certain statements that they allege that Becky Hill made to the jurors, but the state realizes like, oh, some of these statements actually sounds like statements that Creighton Water made in his opening statement and in his closing statement. The parties made their opening statements on Wednesday, January 25th, 2023. The state, as part of its own opening statements, advised the jury. Okay. So I actually have it right here. I'm just going to play it really quick because, you know, why read it when you can just play it?
You're going to see video statements of Alec Murdaugh. You're going to see body-worn camera of him at the scene when law enforcement arrives. And hear what he says. And hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progress about what he says and what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's
That's the statement right there that it seems like a juror have alleged that Becky Hill said to the jurors. But the state's saying they're like, well, you know, it seems like it was Creighton Water who said that. So maybe they're getting it mixed up. So that's one statement right there. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Another thing, the jurors complied and were so closely attentive throughout the trial. At the end of his initial closing argument, the state implored the jury to not let Murdaugh fool them. Closing argument. So I got this one.
This is a sealed exhibit. This is what he did. This is what he did right here. This defendant, on the other hand, has fooled everyone who thought they were close to him, everyone who thought they knew who he was. He's fooled them all.
The audio's off.
And he fooled Maggie and Paul too. And they paid for it with their lives. Don't let him fool you too. On behalf of the state of South Carolina.
So that's also another statement as well that it seems like they're attributing to Becky Hill, which is don't let him fool you too. Now later, the state in its final closing argument returned to the subject of body language while addressing the testimony of Michelle Shelley Smith. Body language is so important in life. Let's see. Body language. No, not pulling up. Okay, I'll just read this one. So he says, do you think she knew right then? And that's real. That's real. Shelley is real. You saw her. Body language is so important in life. Body language. Mr. Waters was talking about the defendant about all of our body language. Did you see Shelley's? What would happen if there'd be a retrial? I was mentioning it earlier. So if there's a retrial, I mean, yeah, it's going to be a mess for the state because now as a defense, they're going to know what to avoid and what to not say and be careful this time. Because this time, you know, if there's not going to be a retrial, I don't know if the roadside shooting thing will come in, if the financial crimes would come in. Murdaugh probably sure as hell wouldn't testify, and they'll be able to give an excuse about the Snapchat video probably, I guess. I don't know. I just feel like it's going to be a whole mess if there's like a new trial. That's definitely something that the state does not want. Imagine having to do that all over again. Oh my goodness. The jurors were not fooled and paid attention to body language and convicted Murdaugh. C. The court thoroughly investigated allegations of improper communication by juror 785 and ultimately dismissed the juror for his communications, but gave no weight to the supposed Facebook post reported by the court of clerk Hill in a conversation which was placed on record. On Tuesday, February 28, after the conclusion of reply examination of Kenny Kinsey, the court initiated an in-camera hearing regarding an email that raised juror concern. In sum and substance, the email represented that the unidentified author heard from an unidentified coworker that said coworker's landlord was a juror who said Murdaugh was innocent and that juror works at the monkey farm. Murdaugh's counsels advised the court to disregard the email as mere noise in a high-profile case, but the state expressed concerns about the allegations of a clear violation of the court's instruction to the jury and noted there was an alternate juror. Wait, so Murdaugh counsels were the ones that said to just disregard it? They didn't want to look into this? Counsel Griffin speculated without support that the email was an orchestrated effort to get the juror removed. Wait, this is a juror that they probably ended up wanting to have on the as a jury member. The court then informed the parties of its exchange with Clerk Hill, who had evidentially learned of the email. The court, okay. After I showed you all this email, we came back here and the clerk came in and asked whether we heard the same thing about the juror. And we're in the midst of trying to figure out who the juror was that this pertained to, since it did indicate a juror number. It did not indicate a juror number. It just said someone who worked at the monkey farm. So the clerk then said she was reading her Facebook messages over the weekend. Gabby, help me out with the fact. Did she say that over the weekend? Law clerk. She said on Friday she was going through her timeline on Facebook and saw a post from this man who's supposed to be her ex-husband. The court. Yeah, ex-husband. The ex-husband of the juror. And his post was that she was discussing the case with various people. I think that's what Becky said. Law clerk. Correct. The court. We asked Becky the clerk, to make a copy or get a copy of the Facebook that she was referring to, the post that she was referring to. She came back a little while later and said that it's been deleted by ex-husband and that she thought pointed out that what remains on his post, which was him stating that he posted an ugly post in which he deleted. Substance of a Facebook apology post, humorous exchange between Mr. Metters and Mr. Harpootlian, the court. But the clerk said that she read the post where he was discussing his ex-wife. The juror had been discussing the case. Now, I was very curious. I was talking about the email and the clerk came in and we're talking about the Facebook post. She said the jurors worked at the monkey farm. I'm trying to figure out what juror works at the monkey farm. And the juror number 785 works at business name, Yamasee, South Carolina, which is a monkey farm, discussing what the monkey farm is. The court. What is a monkey farm? The court says, and the clerk said the juror that they were posting about a juror 785 who works at the monkey farm, and the email referenced a juror who works at the monkey farm. Now, Counsel Griffin suggested bringing juror 785. The court agreed and noted the desire to hear from Clerk Hill, who was not present at the time but had mentioned the Facebook post earlier in the day. After some discussions by the parties as to appropriate procedures and desire of the complainant to remain anonymous, as well as the trial procedural manners, the court conducted an in-camera examination of 785. And so this is the part that we got to see. We didn't get to see the discussion here I believe all this was off camera, but I think it was off camera because I don't remember the monkey farm discussion. Did I remember, like, I think, did Judge Newman ask what a monkey farm was? I don't know. Or if they're like as smart as humans or something. I might have remembered that. Hi, Deanna. How are you doing today? Would they make Maggie's sister testify again? That would just be cruel. I mean, he witnessed, right? Or one of them. The court conducted an in-camera examination of Juror 785 to discuss any conversations that Juror 785 had with anybody on jury duty. As part of a brief discussion about missively alleged posted to Facebook by Jurors 785 ex-spouse, Juror 785 noted that Clerk Hill had alerted her of the alleged posts. The court specifically followed up and asked the court, so has she, Clerk Hill, discussed the case with any of the jurors? Has the clerk discussed anything about the case with anyone on that juror? Not that I'm aware of. Now, Counsel Griffin, then satisfied, accepted Juror 785's explanation and argued that he or she remained a competent juror. Upon the state's desire to know the identities of the person who reported the improper contact with the court again summoned 785 and elicited additional information sufficient to identify the person whom the juror allegedly had improper conversation. Two of Jurors 785 tenants hereafter referred as male tenant and female tenant. So it seems like at the time when this was popping up, Murdaugh's attorneys were like, it's fine, who cares, whatever. But it was the state was the one that wanted to do more investigation into this. Now, shortly after 9 p.m. that evening, agents from South Carolina Law Enforcement Division located them, interviewed them separately, and prepared memoranda and recordings reflecting the interviews. On March 1st, 2023, the 27th day of the trial, the tenants met with ADAG David Fernandez and DAG Donald J. Zelenka and executed affidavits consistent with their statements to law enforcement the night before, which stated that 785 had delivered a refrigerator to them on Saturday, February 18, 2023, and briefly discussed the case. Why, juror? Why? After jury view, the state's initial closing, the court convened that another in-camera hearing to review the affidavits and examine Juror 785's tenant. The court asked male tenant about his affidavit, and the male tenant explained that he offered his opinion about the case to Juror 785, who had disclosed their role as a juror while speaking to the female tenant while delivering the refrigerator. Oh my God, why can't you just keep your mouth shut? Juror 785 replied to male tenant that she hadn't decided either way because it was kind of early in the case. I guess, that she made no decision of it if he was guilty or if he wasn't guilty. The state then reviewed with the male tenant his affidavit line by line. Hi, Morton. How are you doing today? Welcome back. Which he confirmed as accurate. When Counsel Harpootlian asked male tenant to elaborate line 9 of the affidavit, in which the male tenant recalled that Juror 785 stated that she didn't believe there was any evidence to make her think the defendant was guilty at the time. Male tenant expressed that he took her to mean she had not made up her mind. The court next examined female tenant. Female tenant explained that Juror 785 disclosed while delivering the refrigerator that they were on jury, which prompted male tenant to offer his opinion as to Murdaugh's guilt. Female tenant recalled Juror 785, well, I can't really talk about it, she said, but as of now, nothing reasonable doubt could make me say he's guilty. When pressed by Counsel Harpootlian for a restatement as female tenant could muster, female tenant recalled Juror 785 said that she could not without, a doubt say whatever he was guilty. Juror 785 did not explain to female tenant why she held that position. Oh, I see. Female tenant reaffirmed her recollection in her affidavit that Juror 785 indicated that she didn't believe there was evidence beyond a shadow of a beyond a reasonable doubt that Murdaugh committed a crime he is alleged to have committed. This is the point where Harpootlian was like, wait a second. We want her to be on the jury duty. We don't want to kick her off. Let's keep her on here. After hearing arguments, hi, Rhiannon, how are you doing today? Hello. Hi, Ghost Bro. How's it going? After hearing arguments from attorneys for each party, the court noted that in many cases, typically without an inquiry, this jury could have gone, without anything further. The jury could have gone without any discussion because she's discussing the case and was ordered not to discuss the case. Even if she discussed it for a very short period of time, she's having a discussion, so much so that this person understands that it shouldn't have taken place and sent this email. Oh, man. Wait, is she still the tenant? So the tenants are the ones that sent the email? Oh, boy. The court then summoned Clerk Hill to discuss the supposed Facebook post. Clerk Hill explained to the court that she briefly saw a post the preceding Friday on Walterboro Word of Mouth, which she attributed to a juror's ex-spouse, but she said that he noticed that his ex-wife was saying that she was on the jury and saying stuff about her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I kept on scrolling because that was enough for me. I've gotten enough. See, I don't know if I believe that. I feel like she would just screenshot that. You would screenshot it, or you would like say something about it right away to Judge Newman or someone. Like I as the court of clerk, I don't know. I feel like I have a hard time believing that she would just like keep scrolling and be like, oh, nothing of it. Clerk Hill figured the post referred to juror 785 and alerted the court after learning the court had received an email the following Monday. When Clerk Hill tried to find the post again at the court's directive, she could not, but found another post by another account by the ex-spouse's name that apologized for deleting a post made by Drunk and Possessed by Satan. Oh, so they're saying that like she didn't really say anything, and the only reason why she was prompted to say something was because the court was asking her about it and because of the email that popped up. Interesting. Because the way they made Becky Hill seem like, they made it seem like she was the one who was like initiating this investigation, and she was the one who brought this up, and now she's saying there's a post that she saw and now it's deleted. But it seems like she wasn't going to mention the post, but she only mentioned it because this email came in from the tenant. Interesting. After some discussion about the feasibility of finding the devil-afflicted suspected ex-husband, the court asked the parties wish to locate him. Counsel Harpootlian very clearly declined. I think not, Judge. I think if you would just accommodate me, bring Juror 785 in and ask them about the specifics of the conversation. If Juror 785 says yes, I'll have no complaints whatsoever. The court complied with Counsel Harpootlian's request, again summoned Juror 785, the egg lady, informed them the court had met with the tenants and asked if the juror could recall anything further about the conversation. Juror 785 acknowledged delivering the refrigerator and that the tenants had expressed opinions to her about the trial, but denied expressing any of the jurors' thought to the tenant. After discussing Juror 785 ruse to claim that they were in Facebook jail during trial and irrelevant particulars of their employment, Counsel Harpootlian astutely observed the Juror 785 placed their spouse at the scene of the conversation. Juror 785 called their spouse, put them on speaker, and upon brief examination by the court, Juror 785's spouse said that the juror was talking with my tenant's girlfriend. I think, and I know they talked about the trial, but I don't know to what extent, if you know what I mean. The spouse further explained nobody was saying guilty or innocent, but they were talking about some of the facts that had come out in the case either way, Oh, not looking good for the juror. I think the issues that Sled and the clerk knew that the juror may not vote guilty and continue to try to find ways to get rid of her. Tenants didn't tell. It was a coworker of a tenant's pizza shop. Oh, true. Yeah, it was a coworker of the tenant's pizza shop. I forget how messy this was, Alice. Oh my goodness. Okay. The spouse also acknowledged talking if there's any excitement in Juror 785's day each evening, but they did not talk details. Finally, the court granted. So I think initially though, Juror 785 was worried that they were talking about, it was like an ex-husband that she had restraining orders against, I think. And that's why she was kind of pissed about this whole thing. The spouse also acknowledged, blah, 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 I read that already. Okay. Finally, the court granted Counsel Harpootlian the opportunity to confront Juror 785 directly with their tenant's affidavits, which the juror denied as inaccurate. Once Juror 785 was excused and after a brief discussion of the witnesses, Counsel Harpootlian declared, I'm not going to argue anymore about this. I'm going to defer. It's your call, your judgment. Your Honor, I'm not going to argue with whatever you do. Okay. The following morning, March 2nd, 2023, after reviewing the video recordings of the interviews of the tenant, so I guess what they're trying to say is that, Harpootlian and Griffin, they had a chance to really investigate this further, but they kind of just went along with whatever the judge was going to do, and they didn't want to investigate it further. The following morning, March 2nd, 2023, after reviewing the video recordings of the interviews of tenants, the court excused Juror 785 from service for offering her opinion regarding evidence received up to the point and during the conversations with the tenants. Now, Counsel Harpootlian affirmatively declined to take any exceptions to the ruling. Juror 785 was summoned to the courtroom, advised the court's ruling, and upon inquiry about a conversation this morning with Ms. Becky, the court emphasized its ruling had nothing to do with anything brought up about the juror's ex-spouse. Juror 785 possessions, to include a dozen eggs, were retrieved from the jury room, and Juror 254 were prompted from alternate to a panel. So I think initially she probably thought she was being dismissed because of the supposedly post made by the ex-husband, but in reality, she's being dismissed because of her discussing with the tenants when she was delivering the refrigerator. The tenant told the pizza person sent a secret email to the court saying, hey, you have a person who's serving as a juror that works at the monkey farm and they are discussing the trial. Oh man, that was messy. Okay. I had friends that would have their car towed home, rode in the tow truck, driver up front. There was no Uber. Oh man, bet you that was like really pricey. Hi, Henny Wheels. How are you doing today? Yeah, better alternatives than, fucking getting pulled over and going to prison. The jury, which never delivered with juror 785 or alternate juror 741, convicted Murdaugh of killing his wife and son. Upon inquiry by the court, counsel Harpootlian requested the jury be individually polled, which they did. The court polled, and each individual juror affirmed guilty was their verdict and remained their verdict. Less than 1 week later, attorney Joel McCulloch represented the media that juror 785 did not wish to speak publicly about the case and did not wish to be contacted. Rachel Sharp, infamous egg juror in Murdaugh's murder trial, asked to be left alone. The Independent, March 8, 2023. At some point, unknown to the state, McCulloch also assumed representation of juror 630, and so represents that each of the jurors who have provided affidavits to Murdaugh. State's motion to strike. In support of his motion, Murdaugh provides various affidavits which are deficient under South Carolina rules of evidence. Notwithstanding any effort by the state to grapple with the affidavits in its argument in sections 4, right, and 5 below, the state must respectfully move to strike portions of Murdaugh's motion for a new trial as follow. So A, the state moves to strike as inadmissible hearsay the affidavits of paralegal Holly Miller. So again, 2 of the affidavits was not actually signed by the juror members. Apparently they did talk to the juror members, but the juror members never came back to sign the affidavits. They were too busy or something to sign this important document, or maybe they just didn't want to get involved in any of this. In support of his motion, Murdaugh provides 2 affidavits from counsel Harpootlian's paralegal Holly Miller, which largely purports to reflect statements made to or otherwise to her presence by 2 jurors, juror 741 and juror 326. It's going to talk about a hearsay, B, the state moves to strike as inadmissible under Rule 606B. SCRE, all such materials as regard internally functions and deliberations of the jury. Now, in support of his motion, Murdaugh provides 4 affidavits, which purports to reflect statements made by jurors, which in part pertain only to juror mental processes and interactions with each other. As previously noted, jurors may neither testify nor may the court accept affidavits which pertain to any matter or a statement occurring during the course of a juror's deliberation or to the effect of upon that or another juror's mind or emotions, accepting claims of outside influence or extraneous outside information. Remarks in his affidavits regarding jurors' thoughts about the evidence or one another are not properly admissible or even relevant to the ultimate claim raised. Accordingly, the state moves to strike in part as improper juror testimony, motion for a new trial exhibit as line other exhibits. Oh, interesting. C, the state moves to strike all such material as regards to Murdaugh's claims regarding the Facebook posts, the book deal. So apparently they were accusing her of having a book deal, but I think she had like a partner that she was working with who was saying that like, oh, there was no book deal. All this was self-published. It was like out of their own money, I think, that they spent. Book deal, post-trial media interactions, immature, impertinent, and scandalous. The media, the greater part of Murdaugh's motion is dedicated to an outlandish theory that Clerk Hill deliberately fabricated the existence of a Facebook post implicating juror 785 in order to get them removed from the jury, force an outcome, and thereby profit from fame and fortune. Now, it's, again, like, when I first read about this, I was like, oh, that sounds pretty shady, but it seems like juror 785 was going to get kicked out anyways because of other shit that was happening. And she wasn't the one that began the investigation of all this, right? She only brought up the Facebook post after the email came in. So, to be clear, in the attached affidavit, Clerk Hill affirms she made no such deliberate fabrication. She denies fabricating any Facebook posts. Indeed, the machinations alleged do not even begin to make sense. Under Murdaugh's theory, Clerk Hill heard the court had received an email which implicated a specific juror. Then, in immediate response, on the fly, reported fictitious Facebook posts to implicate the same juror. Then conspired with another staffer to quickly and by sheer coincidence be lucky enough to find an apologetic post by somebody with the same name as a juror's spouse, which she then reported to the court in an effort to get an uncertain juror removed so as to ensure some outcome that would support a book deal she did not have at the time. So no book deal. Only Alex Murdaugh could conceive of such confounded gambit as even remotely plausible. And he is projecting his own calculation, manipulative psyche into a dedicated public servant in an effort to save himself. Oh, that's a jab right there. Strategically, Murdaugh's inclusion of the Facebook post narrative appears to be a desperate effort by Murdaugh to preemptively impeach Clerk Hill, to bring into dispute irrelevant facts in order to support his petition for the writ of prohibition pending in the Supreme Court of South Carolina, and to beef up what was otherwise be a thin, blandly legal filing not likely to draw attention to the various media efforts of his legal team. You don't trust the Murdaugh attorneys as far as you can throw them? Whatever Murdaugh's motive, the court expressly did not rely on the alleged Facebook post in removing Juror 785. Therefore, whether Clerk Hill saw the alleged post, is mistaken as to alleged post, or even fabricated it is no consequence to the validity of Murdaugh's conviction or the actual claim raised by Murdaugh of improper external influence upon the jury. Accordingly, the state moves to strike entirely motion for a new trial. Now, number 4, argument number 1. Even assuming ad arguendo that all facts averred in Murdaugh's motion are true, the motion fails to make prima facie, showing that he's entitled to an evidentiary hearing or relief. Why not? Let's see. Although Murdaugh's motion for a new trial makes various allegations as part of the attempt to craft a breathtaking conspiracy narrative, it ultimately boils down to a single constitutional allegation. Clerk Hill told jurors not to believe defendant, thereby violating his right to an impartial juror. Accordingly, even if the state assumes ad arguendo, does that mean like for the sake of the argument? That all of the competence elements of the affidavits provided are earnestly given, the relevant analysis as demonstrated by the questioning of in State v. Green, jury's verdict guilty, jury's verdict based on evidence presented, was the juror's verdict influence the alleged outside communication, the juror have any other communication about the case outside deliberation, all of the other details are irrelevant window dressing. Only one juror who participated in deliberation, juror 630, ties Clerk Hill any statements remotely consistent with Murdaugh's allegation of improper external influence. Not to be fooled. Watch him closely. Look at his actions. Look at his movements. Again, these were phrases that were made by, I believe, Graydon Waters or one of the state prosecutors, or both. Even assuming for the sake of the argument that juror 630 recollection is accurate, that he or she are not misremembering arguments expressly made by the state, Juror 630 does not attribute their verdict to the statements of Clerk Hill, but rather avers that he or she voted guilty despite some questions because 630 felt pressured by other jurors. See motion for a new trial, That a juror felt pressured by other jurors is not a valid basis to impeach a verdict. Nor does juror 630 complaint of feeling pressured by other jurors constitute evidence that he or she or any other juror voted to convict because they were influenced by comments they allege heard from Clerk Hill. Murdaugh offers an affidavit which purports to represent statements made by juror 326, although the affidavit is that of counsel Harpoolian's paralegal, Holly Miller. Even the state accepts ad arguendo that Miller's affidavit is the equivalent of affidavit from the juror themselves. It is unavailing to Murdaugh. Juror 326 contradicts juror 630 and recalled no such comments made by Clerk Hill regarding Murdaugh's credibility. What juror 326 did recall was a warning that the juror would witness disturbing images, which is a neutral trigger warning, and not to put a thumb on the scales of justice. To be sure, the juror did review disturbing images. They did. They had pictures of Maggie and Paul uncensored. Poot is a politician. That should say it all. Ditto. No affidavit attached to Murdaugh's motion from or about a deliberating juror shows any effect on the verdict, even including juror 630. Nothing else offered by Murdaugh's helps meets his burden of making prima facie showing. Neither juror 785 nor juror 741 participated in deliberations and thus cannot aver that deliberations were influenced. Absent any representation that the deliberative juror's decision that Murdaugh was guilty was actually influenced by the improper communications alleged. Murdaugh has failed to make the prima facie showing necessary to justify as to much of the evidentiary hearing, let alone a new trial. According to Murdaugh's motion for a new trial, should be summarily denied. Number 5, argument number 2. Should the court deem an evidentiary hearing necessary, the state expects the material allegations will be shown to be not credible. In the alternative, in the event the court concludes Murdaugh has showing a sufficient to necessitate an evidentiary hearing in this matter, who here in chat wants an evidentiary hearing? Or if you guys just want this to be scrapped? I don't know. I would be okay to listening to an evidentiary hearing about all this. I think it'd be kind of interesting. The state expects a sworn testimony to the court will prove the allegations to be unfounded and not credible. But I don't know if they would stream it though, because it would have the jurors up there, unless they're not going to have the juror's face on the video maybe. Since Murdaugh's filing, the SC Court of Appeals, agents in the South Carolina Law Enforcement Division has successfully interviewed most of the jurors and the final alternative juror. One juror declined to discuss the case or deliberation, juror 578. Two jurors are represented by attorney Joe McCulloch, jurors 630 and 785, who at the time of their writing has not yet to consent to an unconditional interview with his clients. Clerk Hill denies commenting to the jury regarding Murdaugh's defense or testimony. Upon information and belief, SLED's investigation to the allegations of a jury tampering produced the following answers from the jurors who deliberated. So we have juror 198. Did they hear remarks by Clerk Hill? No, maybe generally pay attention. C101 chats with the Clerk Hill with the jurors? Nope. Any other concerns? If anything, people were overly cautious. Jurors 254. Hear remarks and evidence by Clerk Hill? Watch Murdaugh's body language. 101 chats, did not see that. Any other concerns? Nope. Juror 326, no graphic material warning. She saw 101 chat with Clerk Hill and the jurors. Yes, saw chat, financial and child support. Any other concerns? Nope. Juror 530 did not hear the remarks, did not see the 101s, didn't have any other concerns. Juror 544 said, no, generally pay attention, look at the body language and to be observant. Didn't see the 101. Concerns. Juror 630 is a tenant of juror 785 who is upset. Wait, what? Warned by counsel Harpootlian of a subpoena if they did not talk. Wait, what? Are they? Wait, is 630 really a tenant of 785? Because 630 and 785 are represented by the same lawyer. Wait, what? I don't know if that's true though. Juror 572 did not see anything. No. Juror 578 declined to discuss the case or deliberation. Juror 589 did not see anything. No. Spouse warned by Harpootlian of subpoena if they did not talk. Juror 630, no interview. Juror 729, no, generally pay attention, heard no body language comments. Yes, saw the 101. Had chat, financial child support, saw clerk chat with others. Concerns, denied statements regarding them in the affidavit of juror 785. Uncomfortable when Harpootlian waved the gun around. 826, no. 864, no. Concerns, it was Creighton Waters in court argument who told the juror to watch the body language. Oh, so juror 864 was the one who brought it up and the state probably looked into it. Perhaps most importantly, none of the jurors who willingly interviewed with SLED reported feeling any pressure or influence to reach their verdict. In addition to the jurors, SLED interviewed court staff. Jury coordinator Willard Polk Jr. reported that he was the interface between the jurors and the court and did not hear Clerk Hill or any other person attempt to influence the juror. No other court staff witnessed any external influence on the jury either. Altogether, the allegations raised in the affidavits provided by Murdaugh can be explained as a combination of simple mistakes and, unfortunately, a non-credible affiant. As noted previously, a brief review of the record reflects that the verbiage juror 630 recalled is, as juror 864 noted, more properly attributed to the statements of the state. See section State argued to the jury to not be fooled by Murdaugh. The state advised the jury to watch Murdaugh closely. In the context of the video, recorded statements, and the state emphasized the importance of body language. Sounds like several of them agreed that Becky did make comments to pay attention. That alone is improper. I don't know, to pay attention? I don't know about pay attention to this. I don't think so. Unless it was in a way that made the jury influence, unless it was a way to influence the jury to vote a certain way. But if they say that she told us to pay attention, just to pay attention, but that didn't affect with how they came with a verdict, then I feel like that shouldn't really matter. But, I think it would be good for them to maybe do an evidentiary hearing, because I think it would be really interesting to watch that. But I don't know if they're going to do that. I don't know if it's be a waste of people's time. Juror 785, purportedly the landlord to juror 630, was removed from the jury after the court determined he or she improperly conversed about the case with other tenants during trial in contravention of the court's dozens of admonitions not to do so. Juror 785 only recalled the fooled by language was actually articulated by the state in its closing argument the day before juror 785 was dismissed. But most importantly, the court specifically asked juror 785 during an in-camera hearing if Clerk Hill had discussed the case with her or any of the jurors to the knowledge, and juror 785 replied, "Not that I'm aware of." It strains credulity to believe that juror 785 would not be aware of Clerk Hill's supposed statements when specifically asked by the court at the time approximate to when they were allegedly made, but would suddenly recall them many months later after learning Clerk Hill published a book. The remainder of Juror 785 affidavit reports credible one-on-one conversation with Clerk Hill, which, aside from Juror 785 inconsistent but more credible denial to the court, pertain only to the wholly irrelevant Facebook post. Finally, contrary to Juror 785 affidavits in support of the motion for a new trial, the tenant of a Juror 785 affirmed the statements that made in their affidavits at trial and in-camera testimony. Because I wonder if they were to say that, like, oh, pay attention. Like, I wonder if it was just like, oh, just like pay attention. Like, I wonder what was like the context that was set in, or was like pay close attention to his testimony. Like, I wonder what the context was. And like, let's say like, it was improper to say that, but the fact that like if the jurors are going to say that like, oh, she did say pay attention, but it didn't affect me with my deliberations. I don't know. I feel like that wouldn't have any, it wouldn't push them to get a new trial just for that statement alone. The bailiff can wake people up if they're sleeping or something like that, but the clerk should not give any directions on how they are to do or act their duties. Because I just wonder what the context of that was. But it might be improper to say that, but I don't know if it's enough for like, I don't think it's enough for like a mistrial. Oh God, that scared the shit out of me. Hello? Mariko? Did that just pop up? Hello? I think it's worthy of hearing. Yeah, I think it'd be very interesting too. Mariko, are you here? Hello? I just got a gift from you. I don't know if you're in my chat right now. Mariko, hi. How are you? I just got a notification from Throw. That scared the crap out of me. How have you been? I haven't seen you in a while. I know how the cats and everything. Yeah, maybe not a mistrial or a new trial, but hearing to determine if it did have an effect, like you said. Yeah, I think so far the jurors have said that like it didn't influence them in any way. But yeah, I think it'd be worth investigating. But we'll see. Hi, good guy. How are you doing today? What's up, gold locker? All right. Alternate juror 741 would not sign an affidavit as requested by Murdaugh's counsels and was evidently reluctant to do so. See Murdaugh's defense team seeks new trial amid jury tampering reports. The untold story with Martha McCullum. Juror 741 told SLED investigators that Clerk Hill told the jurors that the defense is about to do their side and don't let them confuse or convince you. They may think the defense is about to do their side. Don't let them confuse you or convince you. They may say things to confuse you. However, neither Juror 630 nor 785 clearly corroborated Juror 741's recollection. No other juror even come close to doing so. Juror 741 told SLED that she was aware that Clerk Hill wrote critically of her attentiveness during trial, and additionally noted that Clerk Hill told her after trial that no members of the media wished to speak to her. The cats are doing well. Oh, you can finally join the chat today. How is everything? Are you still in Hawaii? As Judge Newman has a pure stranglehold on the Murdaugh case, the defense has to create discord among the jurors, a court staff in order to file for a mistrial. The greater weight of, did I read this already? The greater weight of the anticipated juror in the court staff testimony is that Clerk Hill had no materially improper comments. The state denies Murdaugh is entitled to relief and anticipates that any evidentiary hearing will only reaffirm the validity of his conviction for the murders of Maggie and Paul Murdaugh. Furthermore, even if Clerk Hill made improper comments to the jury, the state has found no juror will aver that anything Clerk Hill said or did influence their verdict. So yeah, it seems like even if she did make statements, the jurors are still maintaining that they weren't influenced by anything that was said by anyone else. They made their conclusion based on, listening to the witnesses, weighing the evidence and all that stuff. So I don't know. I don't know if we're going to get to evidentiary hearing. We'll see. The court clearly instructed jurors to consider only the competent evidence presented to them and to apply the law as the court gave it to them. The jury presumptively and affirmatively did so. Each individual juror reaffirmed their verdict when polled by the court. Blah, blah, blah. Read that already. Conclusion. Wherefore, the state respectfully requests that this court similarly deny Murdaugh's motion for a new trial, and barring that, convene an evidentiary hearing consistent with which was conducted in State v. Green, and upon hearing the testimony of the jurors and witnesses presented, find Murdaugh's allegation to not be credible and deny his motion for a new trial. Alan Wilson, Zelenka, Mr. Creighton Waters, James Jr. Who's making the decision on this? Was this submitted to Judge Newman? in the Court of General Sessions for the 14th Judicial Court. Because I know that Murdaugh attorneys were trying to appeal to a higher court. But I wonder if this just gets thrown back into Judge Newman's court.